The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Sword. Good morning and welcome to the North Carolina Court of Appeals. We have two cases today for oral argument. As you can see on your screen, we have as your panel myself, Judge McGee, and Judge Dietz and Judge Hampson. The first case for oral argument is State versus Grady. It appears that the attorneys for the parties are ready to proceed. Is that correct?
We are, Your Honor.
Thank you.
Yes, Your Honor.
Thank you. We'll hear from the appellant.
May it please the court. I am Rudy Ashton. I represent Adele Grady on this appeal. I do want to thank you for hearing us. I've been doing this a long time, and this is the first time I've ever had a virtual argument. Seems to be going smoothly so far, and I do appreciate your giving us this opportunity. Mr. Grady was convicted in New Hanover County Superior Court of felonious breaking, entering, and larceny, and possession of a firearm by a felon in March of 2019. The case arose out of a break-in the residence of Jason Gray on March 12, 2018. Mr. Gray lived on Fowler Street in Wilmington. In order to convict Mr. Grady of the breaking and entering larceny, the state relied in great part on what I call sort of a mini trial of a similar break-in on Dexter Street that occurred that same morning. Dexter Street is one block over and parallel to Fowler Street. Our first assignment of error concerns the 404B evidence of the Dexter Street break-in and an accompanying assignment of error on hearsay that was also introduced on the Dexter Street 404B evidence. Our other assignment of error concerns the sufficiency of the evidence to support the firearm by a felon conviction and the denial of Mr. Grady's motion to dismiss. We alleged, first of all, that the 404B evidence of the break-in on Dexter Street was improperly allowed. Basically, 404B evidence, it states evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show they acted in conformity therewith, but it is admissible for other purposes such as motive, intent, preparation, plan, and things of that nature. But it's our contention that the overwhelming Dexter Street evidence basically went to Mr. Grady's character and that he acted in conformity therewith. And I think it's a little confusing. I think the case law basically says the evidence should not show that the defendant had a propensity to commit the offense. And it's our contention and trial counsel's contention that all of the Dexter Street evidence really showed the propensity of Mr. Grady to commit the offense.
Counsel, let me ask you a question about that, because I think what we're going to hear from your friend for the state is that you have the commission of a crime, and you have there's a person wearing a red hoodie that you see going in the direction where that crime occurred, but there's no direct evidence that the person in the red hoodie committed that crime, the Fowler Street crime. But that same day, in that same neighborhood, one street over, a person with a red hoodie committed a breaking and entering, and there's more evidence that the person in the red hoodie actually committed breaking and entering there on Dexter Street. So isn't that kind of almost paradigmatic 404B evidence? So it's not that the defendant has a propensity to commit these types of crimes. It's that we need to know the identity of this person in the red hoodie and whether that person committed the crime. And this is evidence of that. So what's your response to that?
Well, I believe trial counsel sort of admitted that identity was stipulated and would not have really been an issue. The 404B evidence we submit basically went overboard. There was more evidence about the Dexter Street break-in than the Fowler Street break-in. And you had officer testimony, hearsay testimony of James Smith, the victim, who later recanted, videos, photographs, emails, and culminated in arresting Mr. Grady and taking his statement where he confessed to Dexter Street, but denied Fowler Street.
Let me refine my question slightly. So I don't think your friend for the state is going to argue that the identity question was whether your client was the person in the red hoodie. I think the identity question is, did the person in the red hoodie commit the crime on Fowler Street? And because there are a bunch of unique identifying characteristics about the crime on Dexter Street that match the crime in Fowler Street, including that a person in a red hoodie, same neighborhood, one street over, shortly, earlier in the day, committed a breaking and entering there, that supports the fact that the person in the red hoodie crossed the street, went through this camera and then committed the crime. So what's your argument that isn't 404B evidence?
Well, there's no evidence that the person in the red hoodie was actually Mr. Grady. Ms. Overby could not identify that person. I believe Mr. Overby identified Mr. Grady in a Dodge Neon car shortly thereafter, driving down Fowler Street. But it'd be our position that the person in the red hoodie on the video from the cam at Ms. Overby's residence was never actually identified. Mr. Grady was seen in the other break-in wearing similar clothing, but that's really not what I would say goes to the key issue here. The key issue here is the overwhelming evidence of Dexter Street and really no one seeing anyone go into Fowler Street at all. And basically, Mr. Grady, if that was him, was just passing through. And the other thing, a lot of evidence or a lot of items were alleged to have been stolen from Fowler Street. A lot of electronic equipment, personal stuff, Mr. Gray's work stuff with Verizon, several handguns and a shotgun. And the person in the red hoodie leaving had a stop game bag or something of that nature, sort of. It wasn't like a shopping bag. It looked about the size of maybe a large Food Line bag or something like that. And had there been a shotgun in that, it certainly would have stuck out. You would have seen something. And Ms. Overby saw nothing in the bag or anything protruding from it. And then when Mr. Overby saw Mr. Grady in the Dodge Neon shortly thereafter, he saw nothing in the car, in the vehicle, nobody else with him. And so
just to be clear, so and that's not a 404B argument. You're now making a 403 argument. Am I correct about that?
Well, correct. I mean, the argument is that there was 404B evidence went over the top, but even if the judge correctly allowed it in, there is a 403 argument that it was more prejudicial than probative. I believe trial counsel raised that as well, and that's certainly our other argument on this. I cited some cases in there that this 404B evidence should be strictly construed and carefully scrutinized because it can be very unfavorable to an individual and possibly get the wrong person. Most of the cases that rule on this are either sex offense cases, drug cases with repeated buys, and a lot of murder cases. But just because Mr. Grady was in the area that same morning, a block away, does not mean he did or actually could have committed both of the robbery. But we would say that basically, I think there was so much 404B evidence, it overshadowed the actual break-in at Fowler Street. And incidentally,
if I can jump in just quickly, it sort of to follow on Judge Beats's question, it still sounds like you're focused on an argument that this evidence was unfairly prejudicial. You know, really arguing the weight of the evidence rather than whether it was made for a proper purpose. You know, and so what exactly is your contention that there was no proper purpose under 404B that this was admitted, rather than focusing on just the weight of the evidence?
well, as far as the various purposes, as I say, identity was one of them. Maybe a plan. I think the judge instructed about identity and plan in his limiting instruction in the final closing. But again, you know, it'd be our contention that the 404B there was so much of it. I mean, they introduced a video of the break-in at Dexter Street. They interviewed officer testimony, officer interviewing the resident of Dexter Street, who ended up recanting his story and not honoring a subpoena, and they ended up dismissing that case. And another thing that I honestly didn't pick up until getting ready for oral argument, on the Fowler Street case, Officer Moore got the call at 10:17 a.m. on March 12, 2018. And that's at page 32 of the transcript. And that's the case they were trying. Officer Moore is the one who responded to Fowler Street. The Dexter Street video, if you review it, Exhibit 25, and that was the one that actually came in at trial, and transcript page 207 came into Officer Rose, showed that the break-in on the video on Dexter Street happened at 10:17 a.m. And I know they're not that far apart, but to me, it also lends a question that I didn't realize at first, and I don't know that trial counsel argued that either, but it appears that at 10:17 a.m., Mr. Grady or someone else probably couldn't have been at two places at one time. And that's just another reason why we contend that this evidence was so prejudicial. And the hearsay argument sort of backs up to that. It's sort of very unusual. James Smith was the resident at on Dexter Street, and he was at work and got a video or on a camcorder on his cell phone of someone was breaking in his house. He called the police and went out there. He met Officer Rose out there, and Officer Rose basically interviewed him. They looked at the video, they got back up, they went in, they checked the house, and the TV had been stolen. No TV was stolen at Fowler Street. No electronics or guns were stolen at Dexter Street. But anyway, apparently Mr. Smith, when he was subpoenaed to court back in October of 2018, refused to come to court. and then went up and had an altercation at the district attorney's office and ended up getting arrested for throwing his subpoena at the clerk or receptionist's office at the district attorney's office, and basically had recanted what he had said about the break-in on Dexter Street, and that they had the wrong person. But the emails in the discovery, it's a very unusual email for Mr. Smith, was the same right after the incident as it was when they were trying to get him to come to court. And so we believe that the hearsay testimony of Mr. Smith also was improper, and it also affected the 404B evidence. And basically, the hearsay was that Mr. Smith explained the video to Officer Rose. They did a walkthrough of the house together, told him what was taken, looked at everything, and then Mr. Officer Rose based his report based on the hearsay of his interview with Mr. Smith, who never came to court. And so basically, it's our contention on the hearsay that was improper, that also influenced the 404B evidence, and it also was another reason that all that evidence was very, very prejudicial and outweighed the probability.
Counsel, the video itself, if the state laid the foundation, that's not hearsay. Would you agree with that?
Well, video itself, yes, is not hearsay, correct.
And a law enforcement officer testifying, I received a call about a break-in. I went to this location. You know, I did an investigation of a break-in. That would not be hearsay either, right?
I agree, yes.
So I think one argument you could hear from your friend from the state is this was going to be harmless no matter what, because there's no reasonable possibility that had you removed the homeowner's statements, but had the rest of the evidence about that break-in showing the person with the red hoodie committing the crime, that you wouldn't then have a jury saying, well, the person in the red hoodie committed the crime on Fowler Street as well, and we know the person in the red hoodie was your client. So what's your response to that?
Well, I would respond basically by saying I'm not so sure that the red hoodie in the video matches exactly what Ms. Overby saw on her cam with somebody leaving the area. But as far as the hearsay of what Mr. Smith said and told Officer Rose about the break-in on Dexter Street, trial counsel lost his right to at least cross-examine and try to get to the bottom of that issue, especially when Mr. Smith eventually recanted his story about the break-in on Dexter Street, which was then used as 404B evidence to show that Mr. Grady was responsible for the break-in on Fowler Street.
Sir, are you challenging the question about an unavailable declarant and whether or not there was good faith made in trying to have that person available for cross-examination?
Yeah, that's an unusual issue because it did not seem to come up at the trial, unavailability, and yet the district attorney introduced evidence of why Mr. Smith's case, why he wasn't there and why it wasn't tried, and maybe to show the jury why they didn't charge or why they didn't try the case on Dexter Street. I'm not sure. The unavailability didn't actually come up, and in preparing for the appeal, we did a 9B certification and put those records in just in case the district attorney or the attorney general wanted to pursue that argument, and I also thought that it was worth at least bringing him up to the Court of Appeals here. Mr. Smith technically probably wasn't unavailable. All of the altercation and his recanting of the story was in October 2018. This trial was moved until March of 19. They did not resubpoena him or send the Officer Rose out to interview him again. And so anything Mr. Smith said, it's our contention, they didn't prove he was unavailable. And secondly, it goes to a trustworthiness issue as well. And I think we cited the Damon's case in support of that. And it's just very unusual how all of that sort of developed.
Right. I mean, another way to phrase that argument, right, is that this really seems like the opposite of a situation ordinarily where you would allow a finding of unavailability, because what seems to have happened here is that the state was concerned that this witness would recant the favorable testimony evidence that the witness had provided earlier, and so chose not to try to force the witness to come to trial because of that concern. That's precisely the sort of situation where we would say, you're going to admit this evidence, you have to bring the person in so that person can be confronted by the defendant, right?
Yes, and trial counsel, I think, did a good job of trying to explain why it would be important if they're going to use the Dexter Street break-in and Mr. Smith's, what he said through Officer Rose, that he'd have an opportunity to cross-examine him. I would like to move on to the, before I run out of time, the Firearm by Felon case, if there are no further questions on this. Defense counsel filed the appropriate motions to dismiss the Firearm by Felon charge. Mr. Grady admitted his status as a convicted felon. So the only issue was whether he possessed a firearm. The evidence in this case is that no firearms were ever found. A lot of the firearm by felon cases, the question is constructive possession, so there is a firearm. The question is whether the person had control of it. But in this case, no firearms were ever found or introduced. When Mr. Grady was arrested, they searched his person, they searched his residence or wherever he was staying. They didn't find anything there. No evidence was introduced about any supporting paraphernalia in the Fowler Street residence, such as holsters, ammunition, gun case, anything like that. No supporting documentation, bills of sale, gun permits, receipts, anything like that. And basically only Jason Gray's testimony that he had several weapons in the house. He was unable to provide any serial numbers to that as well, which I believe appears in the testimony and on some of the emails. Also,
Mr. Ashley, if I could jump in just quickly on that. So why would a jury not be able, looking under a motion to dismiss kind of standard, why would a jury not be able to withdraw the string of inferences? That Mr. Gray had firearms that were stolen. The jury makes a determination that the defendant was in fact the person who committed that crime, but then he would have been in possession of those firearms. Why wouldn't that be sufficient evidence to go to the jury on this question?
Well, I could see where a jury, and they did seem to have struggled more with the firearm case. They found, I believe the day before, March 6th, they found Mr. Grady guilty of the break-in, enter, and larceny, but were hung up with or split on the firearm by felon. And I believe that went to the insufficiency of the evidence. Obviously, no guns were ever found, and that often happens in cases, but there was nothing else to support that there had been guns there. And there was some evidence that, possibly someone else, Mr. Grady, broke in. Someone else may have been with him, or someone else may have had the gun. Because it's pretty obvious from the overbeat cam shot that if there had been a shotgun, it probably would have been protruding from that bag the person was carrying. And I think there's basically just cited some cases, suspicion or conjecture that Mr. Grady actually, even if he broke in, took a firearm. And there is some evidence, at least came out in voir dire, of someone involved in the Dexter Street incident named Cedric Age. And apparently he had something to do with the TV. And if they were together, then maybe Age got the gun at some other time, or not with them, or whatever. But I believe the jury had some real concern about the firearm case and the sufficiency of the evidence for that. Now, I raised that issue in my brief as well, and Ms. Crowley said it was a red herring, and I understand her position on that, but I would certainly argue it is certainly more than a red herring. You have to look at the totality of the circumstances. You have to look at the timeline. On the afternoon of March 6th, the jury came in with a question only about the firearm by felon and was re-instructed by Judge Nobles. They came in at 4:26, indicate they had a verdict on break and enter and larceny, but not on the firearm by felon, and were split on that. And if you look at page 307, I think Judge Nobles expressed his concern and his propensity, I think, to just declare a mistrial on that, go ahead and get the verdict on the B&E and L, and assuming it was guilty based on the way the questions came about, and sentenced Mr. Grady at that time.
Excuse me, Mr. Patrick, I do need to remind you that you're down to 3 minutes for rebuttal, sir.
Oh, okay.
All right.
All right. Oh, I thought that was going to stop here, but okay. Anyway, basically, I think he would have dismissed it at that time, except the DA suggested they had to come back for the habitual felon phase the next day, and he sent the jury home. And as most trial lawyers know, that's really never a good position for the defendant to be in. But I do submit that there's very little and insufficient evidence of the firearm charge here, and ask that case be reversed. I'll reserve the rest for rebuttal.
Thank you, sir. Appreciate that. We'll hear from the state. Crowley?
Thank you, Your Honor. Generally, don't have to worry about the mute button. Thank you very much. Colleen Crowley with the North Carolina Department of Justice, representing the state in this matter. And starting with the first argument, we believe that the trial court properly allowed the 404B evidence related to the similar breaking and entering that happened earlier in the day on Dexter Street. Rule 404B is very clear. While it doesn't allow certain evidence, it does allow types of evidence that show proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake. And that's what this evidence was. This evidence was very clear. It was about a similar crime happening a block over with a similarly described person, a similarly means of how they entered the house, a kicking and entering of a door. it was appropriate for the court to allow that evidence in. It showed intent, plan, modus operandi, an opportunity to commit. All those were an appropriate means to do that. And as the court is aware, Rule 404B is generally a rule of inclusion. And we then look at whether it's the probative value outweighs the prejudice in this case, and it's very clear that it does. It was offered for a proper purpose, and the ultimate test is if the events are sufficiently similar and not so remote in time as to be prejudicial. And here that's clearly the case. This happened one street over, very similar crime, similar person, same neighborhood, similar means to break in, and as a result, the court properly admitted that 404B evidence. Next, moving on to the hearsay testimony that related to the same evidence on Dexter Street. Contrary to what was presented in the defendant's brief, it was not offered for the truth of the matter. It was not being offered for the truth of the matter asserted. They had wanted us to go through an unavailability test to see if it was appropriately admitted, and the record shows that's not how the state was attempting to admit that evidence.
So let me ask you a question about that. So,
yes, sir.
Most excited utterances or present sense impressions are admitted for the truth of the matter asserted, but they're just an exception to hearsay that's expressly enumerated in the rule, right? So, if you think of the paradigm of an excited utterance is the person who, exclaims that in the middle of a car crash, the blue car just ran the red light, and would be admitting that because the argument is that's true. It's just that there's a sufficient, because it was this excited utterance, the idea is there's not time for that person to have formulated the intent to, for example, tell a lie, and therefore it has this trustworthiness. So
Yes, Your Honor.
What troubles me in this case is that, so if this had been a residual exception case, I think this court would readily say it's not an abuse of discretion to admit it. And the reason would be when you're talking to law enforcement officers and reporting a crime, there is a certain amount of expectation of trustworthiness, because if you're lying, you're committing a crime. You could go to jail. And in addition to that, in the circumstance of a case like this, where you've got all this evidence, you've immediately called the police and said, I want to explain what happened. You can easily see how you could make the argument it's a residual exception case, but that's not what's going on here. This is excited utterance, present sense impression, and I think we heard from your friend for the defendant that this doesn't really fall as readily into those two categories as some evidence. I mean, a lot of time had passed, for example, in the time the crime actually occurred, and then when the witness spoke to law enforcement, and also this wasn't a situation where the witness actually saw the crime occur, right? It was gathering evidence the crime happened afterwards, like watching on the cell phone a video of the security. So how is this a excited utterance or present sense impression case?
I think it fits neatly in the present sense impression. He and the officer met at the location at approximately the same time, the record shows, and they were looking right. He didn't see it occur, but he was watching the video on his phone at the time. And I believe the officer's testimony was that the individual was agitated, excited, and angry about this happening. And I think them both arriving at the same time and discussing it, that is close in time. And present sense impression, there's not a neat box as to how soon it has to happen. And there's case law in that. I would point the court to State v. Cummings. In that case, they found present sense impression where an individual, the victim of the crime, I think the boyfriend had thrown her out, had then driven from Willow Springs to Raleigh and then told her mother about it. And clearly time had passed during that. I don't know if that's 30 minutes or so, depending on traffic, but it's not instantaneous. It allowed some time to happen, and the court found that sufficient. It depends on the circumstances. And the court needs to look at whether the time that passed, is there a likelihood that there was deliberation or intent by the person making the statement to misrepresent? And I don't think that's the case here. I mean, clearly this this Mr. Smith was very upset, very agitated, very much believing that a crime had occurred when he spoke to the officer. And I think, therefore, it clearly meets the present sense impression test as an exception to the hearsay rule. And as a result, I think the court properly admitted that testimony. And I would, unless there's further questions on that point, I think that was very much allowed. The defendant points to the fact that Mr. Smith ultimately didn't appear in court and didn't otherwise discuss these things and seemed to indicate it didn't happen later. I think is not relevant to the present situation. I think it matters what he said at the time. I can't begin to come up with why he changed his mind later, or what intervening circumstances happened, or what the issues may be with Mr. Smith personally, why he didn't want to go forward with this case. But I think what's most telling is what happened close in time to the event. I think that's the most indicative of what the truth is and what happened at the time and what his true feelings were, not what may have happened later in time.
Is there any evidence that the defendant sought a subpoena? Because that would be one way to confront the witness, right? The state's going to put on some evidence and you're just going to force the person to come to court and ask them about it.
Yeah, I don't. I'm sorry, Your Honor. The record doesn't.
I'm sorry.
I'm sorry, it's hard with there's nothing in the record, Your Honor, that shows the defendant sought to get him to come. There were earlier subpoenas by the state, but I'm not aware of the defendant seeking one. And I'll move to the final argument, Your Honors, whether the trial court properly denied defendant's motion to dismiss the firearm by felon charge. And I would point out, in viewing the evidence in this, because the state was successful, the evidence is in the light most favorable to the state, and it benefits from all the reasonable inferences there. And as counsel for defendant has gone through, there's a two-part test on this. One, has the defendant been convicted of a felony, is the first test, and has he indicated, the defendant in this case has acknowledged that he was previously convicted of a felony. And then the second part is whether he subsequently possessed a firearm. As was described by counsel for the defendant, there were 3 weapons at the home that Mr. Gray said were taken and testified in court that were taken. And there were 3 different size weapons. He focuses on a rifle, but there were 2 other weapons as well that were smaller. And there's testimony that defendant was seen shortly thereafter by the Overbys with a bag, a GameStop bag, that clearly had weight to it. There was some weight to this bag, and it clearly was reasonable for the jury to connect the dots and determine that the weapons were in there. You have this individual outside the house. The individual is seen then leaving, or is outside, then from cameras from the Overbys is seen leaving and suddenly has this GameStop bag. The owner of the home testifies that materials are missing from the home, including these weapons. The jury made the correct determination that these weapons were therefore stolen, and at least some of them, if not all of them, included in this bag. And they therefore made the proper determination that he had these weapons on his person, and therefore properly found him to be guilty under this charge of unlawful possession of a firearm by a felon. I think they made the appropriate determination there. They connected the dots, and that was appropriate on the part of the jury to do so. And the fact that they may have taken time, it's hard to say if they took more or less time on this particular charge in determining it. Juries have long days. They have to make lots of determinations. The sanctity of the jury and what's discussed and why they didn't come to that conclusion sooner or later, we will not fully know. And I don't think it is relevant, because it doesn't make a determination by them. They're not graded. You either are or you're not. The fact that it may have taken them longer to get to that determination is irrelevant. I think that they made that determination is what we look at, obviously, and is what counts here. And for those reasons, I would say that the court, Your Honors, should affirm the decision below and uphold the decision of the trial court in this matter.
Any further questions, Judges?
Thank you.
Mr. Ashton, rebuttal, sir?
Thank you, Your Honor. Just briefly, again, we would have the 404B evidence. It just basically went overboard, especially when you consider the hearsay statement of Mr. Smith that was later recanted. And I tend to agree that the present sense impression, while that's a reason to introduce it, I believe it went beyond that. He may have been agitated when they first got there, but basically the hearsay occurred throughout the investigation when they were going through the video together, going through the house together, and there was no witness there to cross-examine. And so we feel both the 404B evidence and the hearsay were more prejudicial than probative, and that Mr. Grady should be entitled to a new trial. As to the firearm by Felon, I would invite you to re-look at the video from the Overbys of that person leaving with the stop game bag, whatever that was. It was not that large a bag. It could not have contained all of that equipment and stuff that was alleged to have been stolen, and it certainly does not appear to have contained a firearm with a shotgun with a 24-inch barrel. And so I would contend that's why the jury had great difficulty in arriving at a verdict on the firearm by Felon, and they certainly could find sufficient evidence of the break-in without finding sufficient evidence of the firearm by Felon. Therefore, on behalf of Mr. Grady, we would ask that you reverse the firearm by Felon conviction and grant him a new trial on the breaking, entering, and larceny. Thank you.
Thank you, Mr. Ashton. We appreciate both of your arguments today. Mr. Soar, could you please adjourn court?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.